Hi everyone. Since I am going to be out of the office, this is uh, basically just a recording of what I would have covered in that Class Connect session for discussing journalism and the law. I know we already talked about ethics a little bit. We're going to kind of just recap on that. And then I'm going to talk about law and then bring up some important court cases that kind of set precedent for journalism and especially journalism in schools. So, um, what want to make sure that you do is definitely watch the whole video. So as you're watching, you are going to, I'm going to ask you to stop and watch a couple of videos that pertain to the court cases that we're going to be discussing. And then once you watch the video, then you'll resume this video as if we were in class, basically. So with that, I'm going to talk a little bit about journalism and law. So this first section has a little bit to do with the history of journalism and law and how things have kind of shaped. So journalism started in the 17th century around then. And then when the first newspaper was introduced to the United States and published, it was mostly factual news and some opinion news came into being, but most of it was factual. Journalism kind of took shape and they were involved and began thinking about maybe developing some standards that they needed to adhere to that were pretty important to make sure that everything was done the right way. So in the 18th century, newspapers were on the rise, and then the various rules of reporters, editors, and commentators kind of developed. Journalism became more widespread, and responsibility became imperative that they started to make sure that they were being responsible as they were reporting. In the 19th century, newspapers, journalism in general, reflected society's divisions. So, like, if you think about today, how we have like the Wall Street Journal and like the Star magazine, usually the Wall Street Journal is read by a certain type of person, and then the Enquirer, the Star magazine, are read by more people who just kind of want to read that fluff. So it's definitely kind of a socioeconomic division of people reading those. But usually, certain papers were developed, they were kind of elite newspapers, and they catered more toward the wealthy and educated. While there was a thing called a penny press, and that was more affordable and it was kind of distributed to the masses. So in the 20th century, objectivity became popular in journalism and a fact-driven hard news standard. Opinions seeping into fact-based stories became less tolerated. So this is where we kind of saw all of the news stories really developing on fact, and people didn't really tolerate anything less, and they wanted to make sure that that information was backed up. It was kind of their reputation to stand behind. And then in the 21st century, obviously that's where internet was introduced, and we became to move away from objectivity and emphasize on opinion and advocacy. And obviously, if you are on any social media website, you can see the variety of different types of news stories, and some you can see are probably pretty factual, and some are definitely made up of people's opinions. So it's gotten a little bit laxed and less factual over time. So with that, we want to look at a few of the ethics and just discuss these real quick because this does kind of go hand in hand with law. So I want to do just a little refresher on this. The first thing that journalists want to make sure that they are is fair. So, does the story represent all sides of the issue, or and does it have bias? So, as a journalist, you don't want to be biased. You want to just put the news out there, and you want to be make sure that it's factual. The next is honesty. Best probably advice in journalism is be truthful because that way you will not get in trouble. But honesty, you want to make sure that it reflects the truth and whatever side of the story is true. Second or third is taste. So taste basically, um, you want to make sure, and we know in today's society there are a lot of news stories that have been written that are not very tasteful. But as a good journalist, you definitely want to make sure that you are writing things that don't include lurid details or things that are going to harm or hurt other people. So you need to kind of have that moral standard there. Credit. Basically, what that means is you just want to, if you're using information from anyone else, you just want to be sure to give that person credit. It would be like plagiarizing, basically. So if you wrote something and turned it in as your own and didn't have a bibliography or a parenthetical citation, you would be plagiarizing. So in journalism, it's kind of the same way. You want to make sure to give credit to your sources. Attribution, basically, writers should provide attribution or a statement explaining how or from or who the information was obtained from. So journalists, you just want to make sure that you are providing that information or that identity. When you don't want to provide that identity is if you have provided confidentiality to someone or if it could harm someone professionally, personally, or legally. And then in that case, you would want to keep that confidentiality. Accuracy, obviously, don't make anything up. You want to make sure that it's as accurate as possible. Okay, so those are some of the ethical standards that as a journalist you should kind of abide by. Um, as we talk about law, we're going to look mostly at the First Amendment right. So in the classroom, when you're looking at assignments and some of the journal assignments and some of the discussion board and other assignments that you're going to be doing, one of the biggest things to look at is the First Amendment right. So basically what the First Amendment right does, it's the freedom of religion, speech, press, assembly, petition. So basically what you're looking at, it's your individual rights is freedom of speech, right? But that doesn't always mean you get to say anything you want to say. So, and here are some concerns that you want to make sure that you are considering. So you need to be very careful as you gather news and report it. The First Amendment right does not give carte blanche to the journalist. So what carte blanche means is it means that you can't just say anything you want to say, right? Just because you're a journalist. There are rules and stipulations, right? So you need to make sure that you're kind of following whatever the rules and the procedures are. Careful reporting will help you avoid legal repercussions. So a historical perspective on libel, and we talked about libel before briefly. And what libel is basically, if you remember, is when someone says something to harm another person, right? You're kind of ruining them financially. Remember, there were 5 things that had to meet that to actually be considered libel. One was you were ruining their reputation. Another was you were going to cause them some type of monetary damage. And there were 3 other things in there. So we kind of talked about that in a different video. But this is a historical perspective on it and kind of what set precedent for it. But John Peter Zenger, he was a colonial publisher, and he was arrested for printing stories critical of Governor Crosby. And this was during colonial times, and the British Crown was considered seditious libel. And sedition, it was to stir rebellion. So basically, they were accusing him of libel and trying to stir rebellion. So Zenger was defended by Andrew Hamilton, one of the greatest legal minds of the time. So Hamilton admitted Zenger's guilt, but pleaded that that they acquit him because he was basically just telling the truth. So Zenger was acquitted, and the truth was established as the defense for libel. So for libel, like we had mentioned before, truth is an absolute defense for libel. If it's true, you can't be sued for libel. So the precedent, so prior cases with similar circumstances also can help you avoid being sued for libel. So basically, precedents become law. So Zanger's case set a precedent and established truth as a defense. So basically, because of this case, now anytime a reporter is being sued for libel, but the information is true, immediately they're going to be found not guilty because this previous case is what they were looking at and it sets precedent. So libel per se, words that need no explanation in order to determine their defamatory effect. So basically what that means is you're calling a doctor a quack or lawyer a shyster or a woman a bad word, that's called libel per se. So you're basically accusing someone of being something they're not, and it's defamatory, right? And then accusing someone of committing a crime. So that's the other thing. If you accuse someone of committing a crime and they have it, that could be libel per se. Libel per quad um, can be explained basically if there's a marriage announcement, it's not libelous until it's discovered that the groom is already married, right? So then it may become libelous. An announcement of lottery winners is not libelous until it's discovered that one of the winners is a minister of a church that takes a hard stand on gambling, the lottery included. So then you would be kind of ruining their reputation at that time. Another good example would be if someone is walking in front of an adult bookstore and they snap a picture of this person, not really a big deal. But if it happens to be a teacher, kindergarten teacher, that could damage his reputation and he could lose his job, which would be loss of monetary, which would be a for um, cause for being sued for libel. So those are just some examples of libel. So like we're saying, there are certain cases that have set precedent. So there are three cases that we're going to kind of bring up and talk about. One case, I'm going to have you actually watch the video first. So pause here, watch the video, and the videos are below this. So the first one is the Tinker versus Des Moines video. So I want you to watch that video first and then come back to this. So once you're done watching the video, then you are going to come back and resume the discussion here on this video. So you should be done watching the Tinker versus Des Moines video. So as you probably learned in the video, Mary Beth Tinker with her mom and her younger brother Paul here. So this is a picture of her actually, and her little brother and the mom. So the big thing was these armbands, right? So they were protesting the Vietnam War. So the principal was like, nope, can't do that. You're not allowed. So they suspended them along with some other people. And there were a bunch of people who said, yeah, that's freedom of speech. They're allowed to do that, right? So um, when they go through and they try to take away that personal freedom, that became an issue, right? So neither students nor teachers shed their constitutional rights to freedom of speech at the schoolhouse gate. So what that means is students have freedom of speech and they are allowed to speak their mind. Just because they're in school doesn't mean that stops. However, there are some stipulations and there are some things that you do it a certain way, obviously. But that was their argument. So student speech is protected from censorship except for these specific times. So if speech invades the rights of others, so somehow you are invading someone else's personal rights, then you can't do it, right? The speech creates a material and substantial disruption of normal school activities. So for example, you decide to get up and walk out of class and you have like a sit-in or you get up and walk out and go stand in the parking lot. You're disrupting class. So at that point, that's not a legal thing. But if you decide to wear a black armband, you're not disturbing anyone, right? For making that statement. So that's why they won their case, was because they weren't disturbing anyone with what they were doing. So um, just a very quick overview of how that case was. So, unprotected speech includes libel, invasion of privacy, copyright infringements, fighting words, speech that creates a clear and present danger, speech that presents a clear and immediate threat to national security, obscenity, etc. So this can't do, right? You're not allowed to libel someone. You're not allowed to invade someone's privacy. You can't have copyright infringement. You can't fight, speech that creates any type of danger. Those things are things you're not allowed to do. Material and substantial disruption, serious physical disruption generally required. So basically, if there's some type of physical or serious disruption in learning, then obviously that's not allowed and you could be in trouble. Um, but in Tinker versus Des Moines, that wasn't the case. They did not disrupt anyone, so they obviously won. So the next court case that I want you to look at, and it's in the note, or it's going to be below here, and it's a link. So it's Hazelwood School District versus Kuhlmeyer. So I want you to go ahead, pause this recording, click on that link, and then when you're done with that, come back to this recording. All right, so you should have watched the Hazelwood School District versus Kuhlmeyer video. And so the East Hazelwood High School, what happened was that the principal obviously pulled two articles, right? One had to do with pregnancy affecting teens, and the other one had to do with divorce, right? So this is the actual paper that was pulled. So this happened in 1983. So when we look at the Tinker versus the Hazelwood, non-school sponsored speech, independent student expression, right? So there was nothing going on there that caused anyone money. There was nothing that was sponsored by the school, nothing like that. So this is school sponsored speech. So this is a little bit different, right? Because this is a school newspaper. So basically, it's curriculum, school funded, and there's a faculty advisor who is getting paid. So this is a little bit different, right? So because the principal viewed that there were reasonable, related, legitimate pedagogical concerns, which is teaching concerns or learning concerns, that is there reasonable educational justification. So in his view, there just wasn't for those articles, right? So the Tinker standards obviously were way higher, right? So the Hazelwood standards, not so much. So according to the U.S. Supreme Court, reasonable educational justification means is it poorly written, biased or prejudiced, unsuitable for immature audiences, ungrammatical, material that would associate the school with anything other than neutrality on matters of political controversy, and material that is inconsistent with the shared values of civilized social order. So some of this is very subjective, but that case unfortunately did not meet what they needed it to win. So post Hazelwood calls to the SPLC from student journalists seeking legal help. So rose at great height, right? So Hazelwood did not create an unlimited license to censor. So that applies only to school sponsored speech. So that was one of their problems. The other is that does not apply to public forum for student media. So that was the other issue that they were facing. So their standard had some teeth, but for the most part, they did not have what it took to win that case and stand up the against the school board. So ultimately, they did end up losing that case. right? So the last case I want to talk about is Dean versus Utica. And so that happened back in 2004. And there wasn't really a good video to show you for this that I could find. So we'll just discuss it. Um, or I'll tell you about it since you're watching a video. We're not really discussing it. Um, but this is an interesting case because this had to do with another student reporter writing about an issue that had to do with the buses and the bus transmission and the bus garage and things like that. So basically, I'm going to give you a background here because the video would have told you what the background of it was. So basically, on March 8th, 2002, Utica High School principal Richard Metesky asked the Arrow advisor to cut student reporter Katie Dean's story about the school bus diesel emission along with the adjoining cartoon and editorial, at the time claiming it was based on unreliable sources and was highly inaccurate. After a year of asking school officials to reconsider their decision, Dean filed a lawsuit. The student, Katie Dean, filed a lawsuit against Utica Community Schools in federal court. On October 12, 2004, Judge Arthur Tarnow determined that the Arrow student newspaper was an example of a limited public forum after reviewing the degree of control school officials exercised over the paper, which ultimately separated this case from the decision expressed in Hazelwood. A limited public forum, in this context, a public forum created for use by the student editors, can reasonably be regulated in terms of time, place, and manner of expression, but not on the substance of that expression. Tarnow also examined Dean's article and determined that there was not a significant disparity in the quality between Dean's article in the Arrow and the similar articles in professional newspapers. In addition, these two factors, the judge decided that the school had censored the article in its own interest by preventing the expression of its viewpoint and claiming it was inaccurate. So basically, the student ended up winning the case because for two reasons. One, because the school they felt was censoring the article because of their own personal benefit, because for them they didn't want anything coming back saying there was something bad about the school. So that was the other one. And then, excuse me, that was one. And the other was that the school officials exercised over the paper, which ultimately separated from this case the decision of Hazelwood. A limited public forum in this context, a public forum created for use by student editors, can reasonably be regulated in terms of time, place, and manner. So because of this, that was the other exception to the rule. So this is the actual article that that was produced in the paper. And this is the cartoon that came along with it. And this is the student who sued the school and won. So because it was a limited public forum, she won her case. And even if not a limited public forum, censorship was unreasonable under Hazelwood. So because of the precedent in Hazelwood that came back, they were saying that the censorship that the school provided was unreasonable because of the reasoning behind their censorship, which was to benefit the school itself, right? So in the Arrow, the limited public forum that they were talking about basically addressed these things. So degree, type of administrative or faculty control, written policy statements, the school practice with respect to the forum, curricular, extracurricular nature of student media, the nature of the property at issue and its compatibility with expressive activity. So if we look at back at Hazelwood and kind of do a little comparison, so fairness, balance, opportunity to respond, grammar, writing quality, well written, to adhere to established journalistic standards, suitability for a potential audience, research quality, no bias or prejudice, accuracy, discipline, courtesy, and respect to authority, timing, could problems with the story reasonably fixed, contin continuity, experience of journalism instructor. So if you look back at the Hazelwood case, obviously a little bit different, but if we're looking at this case, then all of these things were met there. Okay, so with that, what I would like for you to do is make sure that as you're going through and looking at this unit, there are going to be several assignments that are going to refer back to um, ethics and law. So we have that big list of ethics, right, that we gave you that we talked about. Law, we were talking about the First Amendment right, libel, defamation of character, those types of things. So those are the things you're going to be looking at when referring to law, okay? So if you have questions, please let me know. And so hopefully that made or gave you a little bit of clarity and some explanation on some of the topics that had to do with ethics and law. Have a good day.